Wearing of hijab by Muslim women does not form a part of essential religious practice in Islamic faith. This finding by the Karnataka High Court last week formed the basis of the judgment in a case which has been a subject of immense debate. Once the court ruled this, it then asserted that the restriction on hijab was a reasonable and constitutionally permissible one that students cannot object to. But what exactly does essential religious practice mean, and how have Indian courts come to apply this test? And why did the Karnataka High Court finally hold that hijab didn't make the cut? I'll tell you in today's episode of KYC or Know Your Constitution. Now, we know that Article 25 of the Constitution guarantees the freedom of conscience and the right to freely profess, practice, and propagate religion. However, this right isn't absolute and is subject to public order, morality, health, and other fundamental rights as well. Now, these are the restrictions. Article 25 itself does not read any other condition into this right, but courts over the years have ruled that this right would only protect essential religious practices and not all religious practices. So this test essentially decides which religious practices are protected under the Constitution, and that's exactly what this test says. But who gets to decide who and what is essential for a religion and what it isn't? It is essentially the courts that do so. Courts have adopted different approaches to decide this. In some cases, they look at whether the religious books talk about it or how they talk about it. This is in fact what the Karnataka High Court tried doing in the hijab case. The bench basically referred to a commentary on the Quran and held that there is no Quranic injunction or mandate on wearing the hijab. So basically, in simpler words, it referred to texts and commentaries to rule that wearing hijab under the Quran was only recommendatory, was only recommended, wasn't compulsory. The court even went to the extent of saying that if the alleged practice of wearing hijab is not adhered to, it's not as if those not wearing hijab become sinners or Islam loses its glory and it ceases to be a religion. And this is how it reached the conclusion that wearing of hijab by Muslim women does not form a part of essential religious practice in Islamic faith. Now, there are other ways in which court decides this as well. It can also look into whether the practice existed at the time the religion originated. For example, take this case in 2004. The Supreme Court applied this test in deciding whether the Tandav dance was an essential practice of the Anand Marg faith. It ruled that the faith came into existence in 1955 while the dance was adopted only in 1966. So the court ruled that since the faith existed before the practice of Tandav dance, the latter cannot be considered an essential feature of the faith. But the test has faced criticism on several occasions. Several critics have often pointed out that it forces judges into becoming ecclesiastical authorities, often for religions that are not even their own. In fact, Justice D.Y. Chandrachud in the Sabrimala case had lamented that compulsions nonetheless have led the court to don a theological mantle. That means the court is now interpreting the religion. The future of the test is also uncertain at the moment. This is after the Supreme Court referred 7 questions to a larger bench while considering review petitions in the Sabrimala case, as we know. Among other things, a 9-judge bench is set to re-evaluate the essential religious practice test, among other issues related to constitutional morality and the interplay between freedom of religion under the Constitution and other fundamental rights. So basically, the future of this test still hangs on this judgment by a 9-judge bench, which will come sometime in the future. That's all I have for you right now. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram, and Facebook.